Mama Kericho, take the nearest seat. Honourable members, I now propose the question, which is that the Senate amendments to the Water Amendment Bill, National Assembly Bill number 33 of 2023, be now considered. Do we put the question? And go to order number 12. We will return to order number 11.
Order number 12, motion. Consideration of the Public Finance Management Kenya
as appearing in regulations 11 and 16. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. You know what? Let Milema come and sit on the committee. Next order.
Order number 11, Committee of the Whole House.
Order, order, Honorable Soro, assume your seat. Okay. May we resume our seats? Honorable members, we are now in the Committee of the Whole House, and members, as you can see in your order paper, the first, we'll start with the second item there, the National Land Commission Amendment Bill, National Assembly Bill number 43 of 2023. And Honorable Bayer Owen, I think, is move the bill. And without hesitation, I take it you're still consulting. Have you finished your consultations? Thank you so much. So we'll start with the National Land Commission Amendment Bill. And I propose the question.
Clause 2.
I propose the question that clause 2 be amended as proposed. There are two proposals for amendments there by the Lands Committee, and I would invite I propose the question that clause 2 be part of the bill. Chairman of the Lands Committee.
Thank you, Mr. Chair. Mr. Chair, I move that clause 2 be amended as contained in the order paper. The reason or justification for that amendment is that clause 2 of the bill proposes to amend section 14 of the National Land Commission Act through deletions and subsection 2 and 9. However, section 14 of the Act is couched as a transition provision that was to expire 5 years following its enactment, hence the provisions of subsection 1. The committee proposes to substitute clause 2 of the bill to align with Article 68 CV that does not anticipate a time limit where the National Land Commission exercises the function of reviewing grants and disposition. I move.
Thank you. I now propose the question that clause 2 be amended as proposed by the chair of the Lands Committee. Honorable Wundo, go ahead.
Chair, thank you for giving me this opportunity. Probably the chair could also give a little bit further clarifications in terms of the review of the grants and disposition. Now that we are removing any time limit, would probably be interested to know if the disposition and the grant has actually been done by the National Land Commission itself during this currency. How do we approach such kind of a situation, or does the matter now lie directly to the High Court instead of the National Land Commission? So that we understand clearly what's the import of the amendment, so that we don't get mixed up into some kind of a situation where the self-review what I've already done. Because currently, since the new constitution came into place, since NLC came into place, they'll be the one in charge of grants of public land to individuals or any other public entities. So we need to know exactly what's the cut-off date in respect of this particular clause. Thank you, Chair.
Chair.
Thank you, Mr. Chairman. Chairman, what we have is amendments which were moved during the second reading, and it was the feeling of the entire House that the time limit which had been set, the 5-year term limit, was a bit inhibiting to the National Land Commission. That's why we came up with these amendments, just to clean and make sure that we are able to align that particular amendments which was proposed, so that it's in line with the Constitution, so that there are no contradictions. So in essence, what we are trying to do is just to clean up and just make sure that the article, this clause number 2, is very clear.
Thank you. Members, if there's no further intervention on that, I wish to... Yes. What's out of order? Did you say out of order? What is out of order?
Out of order. I wanted to make a contribution. I'm sorry, Honorable Chair.
Oh, we want to contribute. Go ahead.
So could the chair further clarify what the new term is? You have explained everything very well. You wanted to align it with blah, 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 blah. Please just tell the House what then the new term is as per your proposal. Thank you, Chair.
Go ahead, Chair. Just use the one next to you.
I think I was very clear, Chair, that there's no time limit.
Oh, so
no
it's
just
been left open.
Yeah.
Okay, thank you. Members, if there's no intervention on that again, I wish to then go ahead and propose that there's a further amendment by the Honorable Owen Bayer to clause 2, and we invite the Honorable Owen Bayer to move his amendment.
Honorable Speaker, I would like to move a further amendment in the same that we replace the word all after the word review in section 14 of the Principal Act, so that we remove the word all and substitute it with the word any, because it says review all grants. Now, all would mean that the Commission needs to do all grants that had been issued. But then when we substitute the word any, it is any that is presented to the committee. And therefore, I would make that further amendment on the same, on that clause, and subsection 1. Thank you, Honorable Speaker.
Thank you, all members. I therefore propose that clause 2 be further amended as proposed by the Honorable Owen Bayer. Yes, Honorable Wundo.
Chair, it's a progressive amendment and we need to support it. But again, I still go back to the gist of the amendments in totality. I'm not so sure whether the National Land Commission has reported that it was unable to complete the review process as contemplated in the original act, but now that's water under the bridge. The only point that it's trying to raise, which seems to be fairly a good idea, but the point of question is, what happens to that person who does not know, the indolent, iniquity, where we don't wake up a sleeping dog? But what happens, because it says in say any, but the amendment by the committee was that all. So it meant that all the grants and the disposition that have been made will be reviewed. And again, here we don't have any time frame. They can take 100 years, they can 300 years. We need a bit more clarity. See, that's why we are saying we need more clarity, Chair.
Okay.
Whether we are saying any, but after how long? I have been given a title, nobody objected. 5 years, 10 years down the line, I have invested, I have improved the property, and then you come and make a claim. Is it being limited by statute of limitation? You lawyers, you know better,
okay,
of 12 years, or does it exclude that limitation of action so that we leave it open completely throughout? We need that clarity, Chair. See, okay, as I always say, when we are making laws, we must be sticklers to the details so that we avoid a situation where there is too much room to interpret the law as there are many lawyers,
okay,
as in the House. Thank you, Chair.
Thank you. The Honorable Bayer.
Honorable Speaker, I follow what the Honorable Oundo, a good professor of planning, that yes, there has been those questions. But I think the answer to those questions, Honorable Speaker, lies in the Constitution. I would invite you, Honorable Speaker, that you look at Chair, Honorable Chair, that you look at what Article 67E of the Constitution provides, which provides that to initiate investigations on its own initiative or on a complaint into present or historical land injustices. Now, if you look at the word present cannot be limited to a certain framework of time. And therefore, to put a limitation on the Constitution through a statute by saying that we only limit it to 5 years or 10 years or 20 years is defeating the letter and spirit of the Constitution. And therefore, I would like to invite Honorable Oundo to look at it from the prism of the Constitution and therefore agree that we need to do away with the time frame because the Constitution did not envisage a time frame for historical land injustices that are present and in the past. I thank you.
Thank you.
Chair.
Thank you, members. I now put the question that clause.
Though the Honorable Owen has quoted the Constitution, but I thought, because I was reading the bill after it had been called out to order, that we check it. And I noticed that there must have been a reason why there was need to have a time limit. Because yes, there are land injustices that are there. So I took my time and read. But some of those land injustices are even broad and deeply they are more deep than even the level at which we may be imagining. Such that when we open a Pandora of the entire review, even to that level, particular age of time, which you imagine that this is the type, for instance, I'm a historian, and I know there was land alienation. But it gives space to even those who earlier than land alienation may also come up and claim a review. I would want to hear Honorable Owen Bayer's views on that. Thank you.
That's not Owen Bayer's amendment, but let's hear what he says.
Honorable Chair, if you read the entirety of section 14 of the law, it actually tells you what kind of claims will be put before the commission. And if Honorable, the good teacher and Omboko has not read you cannot really look at a law and look at just one subsection 1 only. If you go into the depth of that, you'll be able to understand the spirit and letter of it. So I would request you to look at what is historical and what is historical land injustice. It is enumerated down there further so that you don't just wake up and take any claim there. It has to meet certain parameters and certain standards. And therefore, that guards into how many years we can go down the line. I thank you, Chair.
Very well. This now has to go to the vote, and therefore put the question that clause 2, as amended and further amended, be part of the bill. Will as many of that opinion say aye? Will as many of that opinion say nay? The ayes have it.
Clause 3.
I propose the question that clause 3 be part of the bill. Chairperson?
Thank you, Mr. Chair. I move that clause 3 be amended as contained in the order paper. And the justification is that clause 3 of the bill proposes to amend section 15 of the National Land Commission Act through deletion under subsection 3 and 11. However, section 15 of the Act is called as a transition provision that was to expire after 5 years following its enactment. Hence, the provisions of subsection 1, the committee proposes to substitute clause 2 of the bill to align with Article 67(2)(5) that does not anticipate a time limit where the National Land Commission exercises the function of initiating, receiving, admitting, and investigating a complaint on present historical land injustices. Thank you.
Thank you. Members, I propose the question that clause 3 be amended as proposed by the Honorable Namoko. Is Honorable Wundo?
Chair, again, as it might look very plausible, it must look nice to talk to the gallery, but here we are opening a very, very, very dangerous situation. In the initial bill, the Parent Principal Act, Chair, it talks about the provision of this section shall stand repealed within 10 years, meaning that within 10 years, if you indeed had an issue about any historical injustice, you must have petitioned National Land Commission, you have petitioned the courts, you must have exhausted all avenues. Indeed, the Constitution has been with us for over 10 years. National Land Commission has been with us for all that years. I know this was an amendment brought by Honorable Owen Bayer, and I can understand the historical aspect of it. The absentee landlords, whatever they are. But honestly speaking, Honorable Chair, we must bring some issues to a closure. We must bring some issues to a closure. We can't live in eternity with a problem. We must come at a time, we must bring a matter to a closure. Even when you have a dispute with your neighbor, common sense and fairness requires that we must bring the matter to a closure. We cannot just leave it open forever, because then perpetually the National Land Commission will do nothing else, but it's going to be saddled with boundless and endless complaints of historical land injustice. We have the issues that when we did the survey, the general surveys many years back, the land boundaries were never precise, were never fixed, were never exact. And that's why even the Constitution itself, Honorable Chair, talks about dispute, traditional dispute resolution mechanism. Yet, this amendment seems to be oblivious to the provisions in the Constitution. As much as it is good for his constituency, the coastal strip, the Mazurui, the ward, whichever way, finally, Honorable Chair, the Masais are going to come and claim Nairobi because it's a historical land injustice. But Ashina is here, and is arming himself to do the same. I would suggest, yes, the 10 years have lapsed. We could also introduce another timeline, not just leave it open forever.
Thank you.
Because then, National Land Commission...
Honorable Wondo, you've made your point.
And I can make much more point.
Bring licensing. If you want to be a scrap metal dealer, you must have a license. And also to increase penalties for people who are in situations where they get caught in this vandalism that they have. So that is the third act, Honorable Speaker. The fourth act, Honorable Speaker, is the National Employment Authority Act 2016, number 3 of 2016. The amendment of the National Employment Authority Act 2016 provides that the act shall apply to an employer who employs more than 10 employees. If you have more than 10 employees, then you are subjected to the National Employment Authority Act, Honorable Speaker. That is the amendment that we seek to bring on this. Honorable Speaker, the next is the Fisheries Management Act. In this Fisheries Management and Development Act 2016, or number 35 of 2016, proposes to amend the Fisheries Management Act 2016 to provide that the Cabinet Secretary responsible for matters relating to fisheries will be the chairperson of the Kenya Fisheries Advisory Council. In the past, there has been duplication of roles where you have the Cabinet Secretary, but the Advisory Council is chaired by someone else. Then you ask yourself, who is it advising? You know, and therefore, we propose that the amendments that we're bringing is to have the Cabinet Secretary be the one that chairs the Advisory Council. Just like the President chairs his Advisory Councils, even here we have an opportunity to have the Cabinet Secretary. So this covers the governance challenges posed by the current position on appointment of the chairperson, noting that the Council mainly composed of Cabinet Secretaries. You cannot have a Council that is of Cabinet Secretaries and a Council of Advisors that is Cabinet Secretary, then it is chaired by someone else who is not a Cabinet Secretary. So we want to cover that, Honorable Speaker. Second, on the heels of that, Honorable Speaker, is the Energy Act 2019, number 1 of 2019. Honorable Speaker, this bill proposes to give effect to the recommendations of the Presidential Task Force on the review of power purchase agreements. You remember we have had a lot of discussion in this Parliament that we must review power purchase agreements. We must review power purchase agreements because, so the President set a task force and the task force made certain recommendations, and those recommendations now need to be incorporated into the Act so that they can have a force of law, so that we can have a better regulation, a better regime in terms of power purchase agreements, Honorable Speaker. Honorable Speaker, we have the Public-Private Partnerships Act 2011. Now, this bill, Honorable Speaker, proposes to amend the Public-Private Partnerships Act of 2021 to correct typographical issues of typography. Yeah, yes. No. Typographical and cross-referencing errors contained in the bill.
Order, Honorable Baya. You know, once a member rises on a point of order, we have to hear him. What's your point of order?
Yeah, thank you, Mr. Speaker. Mr. Speaker, I want to know whether it's in order, Mr. Speaker, for a very important motion like this, for this Parliament to pass any important motion like this without a quorum in this House, Mr. Speaker.
So you are rising on which point of order? Standing order. But anyway, whichever way he has raised a question on quorum, and our standing orders are very explicit on quorum, and therefore give me the... Very well. A member has risen from his place, and he has raised the issue of quorum. That is outstanding order number 35. And therefore, I can ascertain that there's no quorum in the House and ask the sergeant to ring the bell for 10 minutes. Proceed, Sergeants.
Well, the House lacks the requisite number of members for the House to proceed with its business, and this is pursuant to the House Standing Order number 35, that at any point after the chair has taken, this is 35.1, that indicates that if at any point the chair is taken or when the House is in committee, a member objects that there is not quorum present, the Speaker or the chairperson shall count the members in the House or the committee as the case may be. For now, it is the House, the proceedings of the House. Earlier on, it was the committee over the whole House stage. So in this case, we are talking about the House, the quorum of the House during the proceedings of the House business. And if on the count of order of count under paragraph 1, if the members present in the House are counted and the quorum does not appear to be present, then the Speaker shall cause the bell to be rung for 10 minutes. That is what is currently underway, a 10-minute quorum bell. This is, of course, to alert the members of the National Assembly who may be within the precincts of Parliament but not inside the chambers to make their way to the chambers, that their presence inside the chambers is highly required for the business to continue. But before the quorum bell, or before that particular interruption on the lack of quorum inside the House, the business on the floor of the House was on the statute law miscellaneous amendment bill. This is a bill originating from the National Assembly, a bill by the leader of the majority party. And it is a bill that is at its second reading stage. The deputy leader of the majority party, Honorable Owen Bayer, was on the floor of the House presenting this particular bill. But because the House does not have the required number, and this is a bill that seeks to make various amendments to various statutes, including the Children's Act 2022, the Copyright Act 2001, Scrap Metal Act 2015, among other statutes, the member rose to alert the Speaker that these are very important statutes, and yet the House does not have the required number of members to be able to enable that particular business to continue. Let's take a look at what these statutes are. Is that the Children's Act 2022, this bill proposes to amend, this bill proposes to remove the provisions which prohibit the court from granting a sole male applicant adoption of a child. This is the Children's Act 2022, number 29 of 2022, a statute that this bill proposes amendments to, and that particular amendment is to remove the provisions which prohibit the court from granting a sole male applicant adoption of a child. The Copyright Act 2001, number 12 of 2001, the amendments that this bill proposes to bring to this particular act is to make provisions for the equitable remuneration of performers and producers of sound or producers sound recordings, and expand the responsibilities of collective management organizations towards the authors and performers. This is the Copyright Act 2001, number 12 of 2001, which is part of the statutes that the Statute Law Miscellaneous Amendment Bill 2023 seeks to bring forth. The amendments also to the Copyright Act is that it also proposes to bring collective management organizations under regulation by the board in order to enhance their efficiency. The Scrap Metal Act 2015, number 1 of 2015 also is part of the statutes that this bill proposes amendments to. Proposes amendments to, which include to provide for a special license for dealing in copper, aluminium, and their alloys. This is intended to protect critical infrastructure, for instance, transformers. The bill further proposes to restrict the disposal of scrap metal from critical infrastructure to 2 national entities, namely the Numerical Machining Complex and the Kenya Shipyard Limited. Just to let you know is that currently is a quorum bell underway. The House does not have, or it happens that the House does not have the required number of members inside the chambers during the proceedings of the House business. And that is what has necessitated that bell. It will be on for 10 minutes. If no quorum is present, at the expiration of the 10 minutes, and if the Speaker is in the chair, the Speaker shall adjourn the House until the next sitting without a question put. This is pursuant to the rules of the House. Order number 35 of the Standing Orders, which guides the House business. The Sergeant at Arms also trying to see whether the members will be walking in, or the division bell will, or the 10 minutes of the division bell will expire and cause the Speaker to adjourn the House until the next sitting. We shall be waiting to see if the members will be coming to the chambers. Well, back to the business that was on the floor of the House before that particular interruption for the bell, with the House lacking the quorum to continue with its business this afternoon sitting, is that the Scrap Metal Act 2015 is part of the statutes under the Statute Law Miscellaneous Amendment Bill 2023 that there are various amendments that this bill seeks to make to, and the Scrap Metal Act is that the Ministry of Industrialization, Trade and Enterprise Development has also proposed the regulation of imports in addition to exports, as well as the enhancement of several penalties in the Act to deter vandalism and other prohibited acts. Well, the Speaker
Very well.
is addressing the House. Allow me to hand you over to the live broadcast.
A member rose from his place on standing order number 35 on the matter that concerns quorum of the House. And indeed, I ascertained there was no quorum in the House. Honorable members, after ringing the bell for 10 minutes, I still ascertained there's no quorum in the House. And therefore, we may rise. And honorable members, and the time being 5:05 p.m., this House stands adjourned until Tuesday, 30th April 2024 at 2:30 p.m.